Hello and warm welcome to all my fellow doctors to this episode of Med AI series, where we explore the intersection of technology and healthcare. I'm Hetvi Shah, your host, and today's episode is special, which is digital health law. It is one that's reshaping the future of healthcare as we know it. And to help us understand better about digital health laws, we are honored to have distinguished guests with us. Our first guest is Amy Joseph, a trusted advisor and respected thought leader in healthcare law. Amy works extensively with clients on developing strategic affiliations, joint ventures, and innovative business models that drive alignment among healthcare stakeholders. She's an expert in creating value based enterprises and navigating complex reimbursement issues across federal programs, private payers, and self pay models. Her insights into legal landscape of digital health is invaluable in today's rapidly evolving healthcare environment. So welcome, Amy, and it is a pleasure to have you here. And joining her is Dr. Dipu Patel, a renowned digital health consultant whose expertise lies in seamlessly integrating digital tools with clinical practice to enhance patient care. So, welcome, Dr. Dipu.
Thank you so much, Hitby, for that kind introduction. And I would also like to extend a warm welcome to Amy Joseph, who's a partner at Oric, Harrington, and Sutcliffe. So thank you, Amy.
Yeah, no, thank you so much. We've been working together for a few years now on various educational materials, and I'm excited to learn just as much from you as I can share anything about health law, because so much of this is how do we implement and what are we seeing on the ground. So I'm excited for the conversation today.
Definitely. And we've seen such an evolution of this space. And I, like you, am learning so much. I'm not an attorney. I definitely think that a lot of the work that is happening and a lot of the movement in the law space that is happening is really impacting healthcare and vice versa. And so we'll dive into our first question, which is, with this rapid evolution of AI in healthcare, what are some of the key legal challenges that you're seeing around patient data and AI-driven decision-making tools and other areas that you may have seen in your experience?
Yeah, so we're seeing a number of challenges in the areas you mentioned, and it's not barriers to entry. It's really everyone struggling to understand where we are with respect to the legal evolution. As everyone knows, it takes time for the law to keep up with the pace of technology, and in fact, it's typically somewhat behind. And so the challenge that I'm seeing is really everyone struggling with how do we appropriately vet tools, which tools are we going to implement, what is our workforce doing with these tools, because all types of regulatory issues can come up. There's certainly patient privacy issues, which we think about. There's scope of practice issues, which I'm sure speaks to a lot of folks on this audience regarding clinician decision-making and how should that work with respect to use of AI that's making recommendations. And various other laws too. I'm no IP expert, but IP is certainly a big topic that comes up often. So with all of these, there's just some uncertainty in how to best manage risk and move forward. I have a perspective that I really appreciate because I often work with health systems and large medical practice and providers, so I understand the perspective that group has. But I also work with a lot of developers of AI. And everyone is trying to do the right thing, right? We're all about improving access and improving outcomes and addressing, administrative burden, but everyone has their own risks that they're trying to address. And I think that's the challenge, is trying to figure out how to best do that without a roadmap, because we're building the plane as we fly it to some extent.
The analogy of a plane as we're flying, it couldn't be more true than it is in this space. I almost feel like it's become an overspoken term or stereotyped term, but it is true. And to your point, Amy, a lot, I work in healthcare and academia, and I kind of feel like things move slowly in healthcare. We're so slow to adopt tools and technologies, and rightfully so, right? I mean, we move with some cautious optimism in a lot of cases. And we think that we're slow to adopt, but I can only imagine what that means from a legal perspective if the laws aren't catching up to the tools that we are utilizing. And so one of the things questions that has come up actually recurrently in our conversations in this podcast is disclosure of the use of these tools, both from the clinician and healthcare provider side, systems side, as well as from the patient side. Because as much as clinicians are using these tools, patients are coming to us with these tools in hand sometimes. And how do you kind of grapple with that? As a clinician, I would grapple with using and trusting data that a patient had brought to me if a tool hadn't or an app hadn't been validated. What are some of the legal implications, I guess my question is, in terms of kind of meshing those ideals together? Because we do want to help each other. We just don't have the framework quite yet.
Yeah, for sure. And it's an interesting perspective of what the patients are bringing. And I've heard some other folks with that too, because I'm not a clinician, I'm a patient, but I always feel like the more information I have, the better. Of course, then it's all put in the clinician's lap to figure out what to do with it, right? But I just view that as another tool that's out there, just like patients who used to go to WebMD or, whatever it is, and you might come with something that's completely off the wall. But yeah, this is a layperson view, but at least that patient is engaged in bringing information. It does put more burden on the clinician to figure out what to do with that. There's more of a legal question to me on the clinician side. When a clinician is using tools, what level of consent or transparency do they need to use? And I'll tell you that up until a few months ago, there wasn't really a lot on the books about this. We all know the concept of informed consent generally. When you're treating, you have to give consent of risks. But there was not that real concept with respect to AI. But I will tell you that we've gotten a lot more guidance in the past few months. So the first being, and it's not binding, but it's informative, I think, is that the Federation of State Medical Boards. So this is, a U.S. organization, which FSMB, all the medical boards are members of it. They issued guidance which came out April or May, I think. And again, it's not a law. You don't have to follow it, but it signals to me where medical boards are headed. Yes, because, it had all the medical boards were able to weigh in and develop this guidance. And it does talk about transparency and consent, particularly if you're using a tool that is making recommendations that the clinician is looking at, that patients should have a right to know. And we also have seen some state laws come out, one out of Utah, which requires anyone using generative AI to disclose if asked, but there's a heightened standard for clinicians. So clinicians using generative AI now need to affirmatively provide that information to patients. And there's a California law, which we think is about to be signed, same thing. So I think that's we're early days, but I think that's the trend that we're going to see, where there has to be transparency, if not consent. And I think it could go the route of consent, that patients need to know and opt in or opt out.
Yeah, that's very interesting. And also now, we can probably go down this rabbit hole quite a bit, but I'm going to move on to my next question. But I wanted to put a finer point on what you just said is patient consent, right? We as clinicians providing this information to the patients and saying, yeah, we're using this. We would like your permission to use it in our clinical decision making. But the larger aspect, and one of the areas that I think is going to grow in the next, I would say, 3 to 5 years, if not even now, is that of patient digital health literacy. We can give them the AI tool, and here's the data, and here's the information, and here's the article and the studies that show that I think this is a good AI tool to use for your case or for your visit. But do they truly understand what they are reading? Because a lot of times this is medicalese. I'm not saying that patients don't understand their own health data, but it's more around understanding the medicalese, and in your world, also the legalese, right, of what we're asking the patients to consent to. Well, I'm going to put that aside because I know that's like a whole other ball of wax conversation. But as you see more and more of these tools being implemented, how is the regulatory landscape adapting to AI in healthcare? You are very well versed in FDA and healthcare regulations. Do you think that the current laws are sufficient to address what we have currently, or the risks, or do we need new legislation? A little bit of both.
Yeah, it's a great question, and I want to be careful here. I'm thinking about all the different stakeholders that I represent.
Yeah.
So I'm gonna remove it a little bit from personally, what do I think we need, and I will just say it's coming. New legislation is coming because enough people think that there's not sufficient oversight right now. But I think it's worth taking a step back before we talk about what's coming down the pike, because it's also not the Wild West right now. There are a lot of existing laws which govern all these tools and govern clinicians' use of the tools. So HIPAA, for example, when we're talking about patient privacy rights, that applies to the use of AI just like any other tool that is used in healthcare. And so there is significant amounts of oversight, or if we talk about bias, right, and discrimination, which is a huge issue and a very complicated issue to unpack. But we have in the US, we have existing laws which apply broadly that prohibit discrimination. And so those laws apply equally to use of AI and AI tools as they would anywhere else. The agencies have come out, they've made clear statements about that. They're prepared to enforce in the context of AI as with anywhere else. So it's not like we're flying blind with no rules. It's not a free-for-all right now. But, the more customized that a law can get, the easier it is to understand exactly what is expected and what's not, which can provide some comfort. If you know that you have to do X, Y, and Z, and then you're in compliance with the law, that can be helpful. And I think, the laws that we see, and there's hundreds of laws right now that are being proposed. It's just, it's a full-time job to try.
You have a job. You will have a job for a long time, Amy.
Yes. Yeah, for better or worse, lawyers are we're very busy with this right now. But I see there are themes that are coming out of these laws. And one of those themes is transparency, which we already talked about. How much should consumers know if tools are being used and if their data is being used as part of these tools? There's a big theme of transparency, and there's a big theme about risk management, about any developer or deployer of these tools. Do they have internal policies? How are they determining which tools to use? How are they reducing risk of bias? So we see a lot of push for self-governance, if you will. And then we're seeing a push for enforcement. Who's going to enforce this? And the Attorney General of each state looks to be a frequent flyer proposal. So if there are any issues, attorney generals generally in states already have a lot of authority around consumer protection. So there can be federal laws as well, but at the state level, each attorney general has a lot of authority to go after businesses that they think they're doing something deceptive or misleading or harmful to consumers. So it's a natural place for enforcement to sit. And we're seeing that theme in a lot of proposed state laws as well. So we're going to be busy for a while. I think that the legal landscape is going to look really different in another year or two. And of course, the technology will look really different in a year or two as well, because it's always a game of catch up.
Yeah. Well, one of the things that, and please correct me if I'm wrong, one of the areas that I often kind of think about is a lot of the technology and the tools that we use now within the AI space didn't exist 10 years ago or maybe 20 years ago, right? So we've had to redefine what technology means, and the FDA came out with the SAMD references and kind of really categorizing devices in certain categories. And do you foresee that kind of evolving as new tools come to market? And it's not necessarily a legal question, but I kind of feel like that's the framework around which we make a lot of our decisions, and a lot of developers make their decisions as well. Like, where are they going to go to market and get FDA approval? What are your thoughts on that?
Yeah, I do. So I agree with you. I see the terminology changing quickly. I see the actual technology being used evolving quickly. I know for us, even just trying to describe what digital health is should not be that hard, but it's actually
very hard.
Yes, because it's capturing anything digital in the delivery of healthcare, and that can be huge, that can be narrow, Folks who are focused on telehealth, they think of that as digital health. Folks who are thinking about FDA medical devices, that's digital health. It can mean so many things. And we're always seeing new technologies. So the definition has to expand. And I think regulators need to try and stay apace of that. If we think about generative AI, I mean, that's such a household term now, but a couple of years ago, that was not a household term. So it's a time of extreme change and adaptability needed from the clinicians and the lawyers as we go through this.
Yeah, absolutely. And that is one of the things that you're right. The definitions of things are going to change, and how we categorize things are going to change. You're right. Like I use digital health as that umbrella term for all of these technologies that kind of sit under, and including AI, right? But that will change. I'm confident that it will change in the near future, where we'll start kind of spicing and dicing all this terminology. So if I may,
it's one of the few things we can be confident about, is that things are going to change.
The change is going to happen. Yeah, it will be continual. Exactly. So pivoting a little bit, like if we were, let's pare down to like a specific medical recommendation. So if an AI system were to make a medical recommendation that led to a negative outcome, who holds the liability? Is it the healthcare provider, the developer, someone else? And are there cases that you can point to that have kind of been litigated under current laws that you can give us examples of?
Yeah, so I'm not aware of any cases yet in this space focused on AI in the clinical decision-making space. Okay. But I can tell you where I think things are settling on this question. And it's perhaps not a popular answer to clinicians, but I'll just tell you where I think it is, that ultimately these tools are considered tools. They're supposed to support the practice of medicine. They're not supposed to supplant the practice of medicine. And that's because, they are not licensed healthcare professionals. It is a technology. It can miss things. Their tools are getting better all the time. It's not a licensed physician. And so if you were to ask a medical board, they would say that ultimately the buck stops at the clinician. They should be independently reviewing the recommendations and making a determination. And ultimately that's what patients expect of their doctors. Right. So there is liability for physicians if not acting within the standard of care. And that could be if they're just looking at an AI output and not independently thinking, is this the right decision for this particular patient? That could be viewed as not standard of care. And the FSMB guidance that we were talking about comes up pretty strongly on this. But I will say, I do think there's liability for everyone, potentially. Yeah. It's not to the exclusion of the tools having some responsibilities, right? And where we see this come up is really in the contract negotiation. So if a clinician or a medical practice or health system is looking to contract for use of a new tool, there will be a lot of back and forth around who bears the liability, if something goes wrong with the technology, what types of warranties are you getting, not to get too in the weeds on the contract negotiations. But, because it is kind of a shared responsibility in some respect, because if the tool just, is all over the place, that can make it harder for clinicians to do their job. So we deal with that through the contract, but ultimately the physician is really the human in the loop that should be reviewing and making the decision. And there can be liability if they do something not in the standard of care.
I think part of it, like my viewpoint on this, is that, as you said, it doesn't supplant clinical decision making. And when I teach, part of it is, critical thinking is going to be even more important now than ever, especially when you start using AI tools as quote unquote safety blankets for your decision making. And I like to. One of the things that I think when we're talking terminology and differentiating terminology is, we use critical thinking. Well, thinking is a human endeavor. These tools are not thinking, they're processing. They're processing data and they're doing math to give you the answers, sometimes correctly, sometimes incorrectly. But I would kind of like to, as a human being, own the term thinking for our species rather than, you know, giving it to an AI. And I think that's the difference that we need to kind of start putting out there, where critical thinking is a human endeavor used in patient care, and computational processing is what these AI tools do to allow us and augment the critical thinking that we do it and ultimately apply to the patient. So that's kind of how
it's such a great way to put it. And I like the word of augment. You know, the AMA, the American Medical Association, was very intentional in calling this augmented, not artificial intelligence. And I've heard, now this is, I don't know where the site is, right? This is not, but I've heard in kind of just being in this world, that there have been studies that show can be also some unintentional bias in when you look at the output, that thinking that output is right. And so thinking about the critical thinking to really look at it independently and say, let me just take a beat and make sure I think this is right. You know, because I think that's human nature as well, right?
Of course.
You know,
I mean, and also
right.
The AI is very convincingly good at convincing you that even the wrong information is correct. And so your judgment as a human being, your experience is really going to speak to, you know, what, if we were talking about patients or in your line of work, you know, case law, where, I mean, I've read articles where it's made up case law precedent and has completely. And so I think part of it is really understanding that this is not a threat to our jobs. In fact, it'll enhance our jobs, but it'll make our jobs even much more critical in the long run, because we are going to need human beings to kind of add that critical thinking aspect of it and that application of it. So I would just kind of digress in that space, but yeah, I think it's really, really important. So speaking of computational processing, these AI systems and tools often rely on massive amounts of data to learn and improve. And the more questions we ask it, in theory, the better it should get at answering our questions or someone else's questions, right? How are privacy laws like HIPAA and GDPR in the EU that apply to healthcare? What are some of the biggest compliance risks that healthcare organizations face? You had mentioned earlier that, you know, patient consent is ultimately kind of where we're going to sit with all of these, the applicability of these tools. But at some point, we do need to teach the AI to learn. And it does need data, and ideally real patient data, so that it can provide real feedback. What are your thoughts on compliance risks around that?
Yeah, and to circle back, to start from your last comment, is I think the place to start is the tools do need data. I mean, that's just, if we all are kind of bought into the idea that these tools can ultimately help deliver care, whether it's through clinical decision making or even just helping reduce burden, right? Helping with medical documentation or other types of even revenue cycle management. And we see so many tools out there now in revenue cycle management. It needs data. And if you want to try to mitigate risk of bias, you really need robust data from all different types of patients, all different types of parts of the country. You know, and it's a constant need, because you want to be continuing to train and improve these tools as you go. At the same time, right, this is very sensitive information that's subject to HIPAA. I don't know GDPR as well. I'm very much a U.S.
That's a U.S. Yeah, no worries.
You know, the policies behind it are really similar to HIPAA, that we really want to, not only want to, but, you know, we're obligated from a legal perspective and an ethical perspective to protect our patient information. Not that there's tension, because there is a way to do this, but the risk that healthcare providers worry about is how much can they trust the developer, and how much data are they willing to share. So as a general principle, when a healthcare provider is working with a developer, the discussion really comes around de-identified data. So is that provider willing to strip out all the identifiers, and are they confident that stripping out those identifiers is enough to truly make it de-identified. I mean, that's kind of question one, whether a provider is comfortable doing so. And then if they are, then through the contracts, you negotiate the developer's right to have that data in order to train their tool. I'll tell you, and I'm kind of I've been a privacy lawyer for a long time. It's been a part of my practice. And there are these agreements called business associate agreements, which you're probably familiar with and others might not be, but it's essentially an addendum that gets attached to any contract when you have a vendor or a technology provider providing services to the clinician or the practice, which lays out all the requirements about keeping the data safe. And these used to be addendums. You might spend a little bit of time negotiating. It now drives the deals because I mean, it's because often the whole point is to get access to this data because that's what you need to improve the tool. And then providers are rightly concerned about making sure they're protecting the data. And really the comfort level is different per provider. I will just say, and I'm going to show my little bit of bias towards developers here because I think they do need the data, is there's a way to do it. It's just a matter of getting comfortable with the vendor, asking the right questions, and making sure you have the right contractual protections. Because it's key to yes, trust. And there are a lot of vendors out there. A lot of providers have started asking more questions. You can do some due diligence on security, make sure it's not just lip service, but the vendor really understands and is committed to protecting data. But it is, that will often be the thing that draws out a negotiation. Even when all the money terms and everything else are done, we're still talking about data rights.
Right. And I was recently speaking to a class, to a colleague actually, and one of the things, the question was asked around how are they getting all this data? And I was like, well, if you've ever downloaded an app on your phone, or if you have a smartwatch or anything, I'm going to tell you, I don't read every single, I'm scrolling through the consent. I'm giving my data away for free. Like that's the part you're talking about, right? On the back end, on a greater scale, like as these developers are putting their apps or whatever it may be in a healthcare organization or on a phone, the data is the thing that drives that AI, that model's algorithms ability to be accurate or not accurate or whatever, do what it is meant to be done, right? Meet the objectives of whatever that app is. So data has become more and more the driving force in a lot of these technologies. And I'm gonna bring up a topic and then we're not gonna talk about it, but like that's where I think synthetic data is coming into play for a lot of our research and development areas, where we're using existing data sets like the ones that you're talking about that are being negotiated, and then using them to develop synthetic data sets in order to train these algorithms. Now, there's pros and cons to that, right? Are they real? Are they not? Well, in theory, they're not. Are they biased? Are they not? Like all of those things come into play. And if you build a synthetic data set on a already biased data set, that bias is going to carry through to the data sets that you build going forward. So that's a whole other conversation, but I can imagine that my information, your information, all of our information and data is going to be so important. Google, Amazon, all of these big companies have literally built their companies on our data. And we've kind of let them as a culture and we're okay with it. But I think this conversation is going to be surfaced more and more as we kind of, go into this AI world, especially when it comes to healthcare data, because I think that's really where a lot of the good and the bad can happen, right? So I'm going to digress. So in terms of the bias, as you had mentioned, the potential for bias for in a lot of these areas, from a legal perspective, what are the conversations that you are having or our healthcare organizations are having around fairness and discriminatory outcomes in these algorithms as they're implementing?
It's certainly a topic that's on the forefront of everyone's mind. And I think we're all aware of stories that have come out that are clear evidence that these tools can lead to bias and discrimination. I think the one I hear most often is at the height of the pandemic and crisis standards of care being implemented at hospitals and decision-making wrongly relying on certain historical data and making assumptions regarding who needed care based on how much care they would have gotten in the past, right? There's pages and pages of examples in some recent commentary that CMS put out. It's really fascinating and disturbing. There's the risk is there. It is a tough position, I think, for healthcare providers to be in, particularly smaller providers, because they're trained clinicians. They're not trained, right, to understand the ins and outs of discrimination or technology necessarily. The larger health systems, I think, have more capability to put in various committees to really look under the hood of the tools that they're using and to do more piloting. I think it's harder for the smaller provider, but it is certainly an issue that everyone is trying to be mindful about. We also have new regulations that came out in May, and they stem out of the Affordable Care Act, and we're years after the Affordable Care Act. But for other political reasons, which we don't need to get into, these regulations have stopped and started quite a bit over the years. But they're new as of May, and that they specifically say that certain providers, so if you take Medicare or Medicaid, you're expected to make reasonable efforts now to make sure that the AI that you're using does not result in discrimination. And when this regulation comes out, it makes sense in theory. The question is, how do you really do that, right? There's not a lot of guidance about how to actually do that. It just puts
how do you define reasonable? Yeah, how do you define reasonable?
Right. Yes, and a lot of commenters wrote to the government and said, "How are we supposed to do this exactly?" And not a lot of satisfying answers. No enforcement in this area yet, but it, at least based on that regulation, it's putting the burden on the provider to do something. There is a new certification for developers, which is voluntary at the federal level. It's not required, so not every developer does it. But if you do it, there is a requirement to provide transparency on the data inputs and what the developer is doing to mitigate bias. And I'll tell you that developers are trying to be responsible, and they are also doing everything they can to mitigate bias. So there is an opportunity to have those discussions with the developer of the tool that you're contracting to use, to try and get a sense of how much have they done. And to me, that is a good step to take, even if you don't have a committee and an expertise. At least asking some questions to the developer and piloting to get a sense of if you think the tool is mitigating risk of bias is a way to go. But yeah, it's such a tough topic, and at least so far, I think the regulations are looking back to the clinicians.
Yeah, no, and I mean, I think although the clinicians, as you said, currently are kind of bearing the brunt, right? I do think the space will evolve. And what I find most promising is that all of the stakeholders involved in these conversations are having those conversations around transparency and bias and ethics upfront. Yes. Historically, I mean, this is my bias coming out, which is those things were often not the thing that led the conversation. And I think what is nice about these tools is that those conversations are being at the forefront of the development of the tool, of the use of the data, the application of the data. All of these conversations are being had up front. And I think that is a change for the better, a pivoting for the better when it comes to the use of these tools, because that builds trust across the board, right? From all of the developers, the patients, the healthcare provider, everybody. I think that really builds that trust to use it. And that's really the only way we're going to end up actually implementing a lot of these tools into our practice. In a safe way.
I agree. And I'll say as well, because, I do have such a broad client base, I really do think, I'm not going to say everyone, but I mean, really think 99.99% of anyone in this business, whether you're a clinician or you're developing the tool, you're in it for a reason, right? There are other ways to go make tons of money, right?
Yes.
As opposed to healthcare. And so I think, kind of appreciating that and coming to the table with that type of understanding, because everyone that I work with on the developer side, they're really motivated to do something to help move the ball with how healthcare is delivered. And so I think everyone is trying to do the right thing, but still it's important to get to know each other, to ask questions, to track the legal developments, because I think we will see more and more guidance about how to better mitigate risk. And it's kind of everyone's shared responsibility to track that. But I do think, for whatever that's worth, and I'm a lawyer, right? Like but if I'm going to be a lawyer, at least I'm working in healthcare, because I do think that everyone is really motivated by some common principles here.
I do think they come with good intentions at hand for the most part.
Yep.
Not everyone, there's an exception to everything, but
there's always an exception.
But I think that usually most people will come to the table with some good intentions. So you had mentioned in terms of the regulatory space, the FDA has really started not heavily, at least intentionally started to regulate some of the AI-based healthcare tools they've been doing. I think radiology tools are leading the way in this space, and more keep coming. I think last time I checked, we were well over 1,000 AI tools that were approved by the FDA. Do you think the agency is keeping up with this fast-moving nature of AI innovations? And do you think its role is going to evolve?
Yeah, and so I'll caveat this with that I'm not an FDA attorney. I work with a lot of FDA attorneys. FDA focuses more on the product, if you will, and I work more with clinicians and delivery. But so grain of salt, right? But my bird's eye view is the FDA, from what I can see, has been more active in this space for longer than most other agencies. To your point, I mean, we've got over 1,000 now. Last I checked, it was over 800 or 900, and that's just what's already been approved. Imagine how many are in the hopper, right? So they have some experience with this, and we've seen over the past few years more and more guidance coming out as they're trying to update their processes to align with technology. Are they right with technology? I can't say, but I do think they have seemed to have been more involved and more proactively tracking this than other agencies. So I would expect that they would continue to do so. I'm seeing outside of radiology, I'm seeing it across all fields now. I mean, cardiology. More and more.
Yeah.
Yeah.
Cardiology, pulmonary, and metabolic diseases are really starting to, and surprisingly, but not surprisingly, surgical AI tools are also becoming really are picking up pace in this space. So I for one, I'm very excited about a lot of these tools, but it is, for a while, as you said, even though the FDA has been a leader, we didn't have enough expertise in this space to really speak to both aspects of it, right? We have the technical expertise, but we may not have had the healthcare expertise or the legal expertise. And I think as we all are kind of learning together, we're starting to gain some confidence and skill levels around addressing a lot of these issues. And I think that's true for the FDA as well. I think they've really grown as an agency because for a while, when Gen AI first came, they were just like, nope. We had a number of radiology tools, but we didn't have much in way of other spaces. And I think they've really tried to reframe their thinking around all of these tools. So
yeah, and I know for us, and I tend to again represent more providers as well as the developers. When we're thinking about clinical decision-making tools and having that guidance out from the FDA now about what that means and when are you exempt from the device, it's really significant. It's made a significant impact to have more clarity around that for my clients.
100%, I would agree. In terms of beyond the legal requirements, I guess, what are some of the ethical issues in healthcare that healthcare organizations should consider when adopting AI tools, and how do you kind of balance patients' rights with innovation?
Yeah, it is
a hard one.
It is a hard one. You give me all the hard questions today. I think we touched on some of the themes where we might not have a specific law yet, and then it's really up to the provider to think about ethically what makes sense. And again, I'll focus in on transparency and disclosure to the patient if you're using tools. I cannot tell you that that's required everywhere. I don't think it's required in many states right now. And I really think it's up to the provider, what they think makes sense and what type of disclosure is effective too. Like you said, I mean, we can add legalese all day long. Like you said, everyone clicks through. I click through those things sometimes. And so they can be useful. I mean, sometimes I read them, but thinking about even the words that we use when we disclose to consumers, make sure it makes sense, make sure it's readable, make sure someone walks away less confused, not more confused. So I do think that's something that I see a lot of clients thinking through above and beyond what the law might require.
Yeah. Well, as we're kind of rounding out this episode, I'm going to ask you to kind of weigh in on what you see the future of digital health law looks like in relation to AI. And are there any legal trends or changes that healthcare organizations can do or should be preparing for as this landscape continues to shift?
Yeah, I think the biggest thing, and we talked about early on, we already all have full-time jobs. I think this is a job on top of it, is just tracking what's happening, because there's so much being proposed and there's so many laws being worked through. All of them are not going to get on the books, right? That's how this goes. But there's so much focus and attention on this. And sometimes there'll be a long runway between when a law is passed and when you have to comply. You might have a year or two. Sometimes you have 60 days, so really tracking and knowing where the law is headed, if there's new guidance coming out from a medical board in your state, that's the best way to promote innovation while protecting. And so I think, and I know we're tracking it, law firms everywhere are tracking it, right? A lot of folks are using AI now to track the developments in AI. It's kind of feels full circle.
Using the tool to track the tool, right?
Yes. And I honestly think that's the best thing that folks can do, because the laws are changing so much. And while I can predict themes and where I think kind of the principles are of the laws that we're going to have, I cannot tell you what the specific rules will be till we have them.
And they may change, because I think a specific law may be proposed and a new technology comes to light, or a new case application comes to light. We may need to shift the law to kind of amend the law, or whatever nomenclature we would use for that. So,
that's right. Yeah. And at larger clients, there's, aside from having a privacy officer and a security officer and a compliance, we are now seeing AI officer roles more and more, which might be because it's just, and it's a good thing, right? The technology is really finding new ways to advance care, but it's just integrated into everything that we do at this point. And so I think organizations just dedicating the time and resources to that can be helpful too.
Thank you. Well, we have a couple questions from our audience, if you would be willing. One question from our audience is, as digital health tools become more advanced and integrated into daily practice, how can healthcare providers effectively document the use of AI tools in patient records to ensure both legal and clinical accountability? I think this goes to our disclosure of the use of AI tools in clinical decision-making that we talked about a little bit earlier.
Yeah, it's such a great question. I'm going to give a very unsatisfying answer. And that's simply because I'm not a clinician, and I understand that the EMR, whatever system you're using, has it's you can't just, it's not like a creative writing exercise what you can put in there. But I do think finding some means to track is important, to know when a tool is used on a particular patient. You might have a better sense than I do about how to technically make that happen, but documentation is helpful.
Documentation is certainly helpful, whether that's a templated sentence at the top or the bottom of your note, saying that XYZ tool was used in the clinical decision-making or treatment and management of this patient, kind of disclosing it. And then I would also disclosing the version. Also, a lot of times the EMRs will automatically kind of document that as you kind of click through, depending on what kind of tool it is, if it is integrated into your EMR. Right. If it's not integrated, then it's up to you because you do have to. And I'm sitting here thinking of the kinds of tools, AI detection tools are like ultrasound machines that tend not to be integrated into the EMRs. And we're reading the quote recommendations of what the AI is putting out in terms of the algorithm. And we're kind of augmenting our decisions around it. I'm not an ultrasound technologist, but you can imagine that part of it, right? Like, and knowing that we're using XYZ algorithm for that date and time, because what we didn't discuss a lot in depth here is version control, right? We have 2.0 and 3.0, and as we kind of do all of our beta launches and whatnot, it's really important to for quality control of these algorithms so that we know if there was an error, if there was something that went wrong, we would know where to look for the bug fix or whatever it may be. So yeah, so whatever system you end up using, I think it needs to be transparent. And I would argue that even if it is integrated into your EMR, having a sentence saying that I used this, like I acknowledge it in some way, shape, or form, is really helpful. Much like we would document, positive strep test or negative flu test or whatever. In our note, we often, that we document that, and I think that would be part of our documentation process going forward. So one more question from the audience. Since AI systems are largely based on pre-existing data, how can we ensure that this data is accurate and adaptable to real-world diverse clinical cases? Can we truly rely on AI without questioning its limitations? I mean, I think I know the answer to that. I think I know what you're going to say to this, Amy.
Yeah. Well, and I think it's a two-part answer. So one, how can we know if it's the right data and is it adaptable? I mean, those are things that developers are really thinking about, and those are questions that you can ask. Most developers do have governance policies in place where they're trying to make sure that they have sufficient data. They're going back and testing, they're checking, but those are questions that you should ask. At the end of the day, though, ultimately, the decision does rest with the clinician.
Yeah, for sure. Yeah, and and the answer is we cannot truly rely on AI without questioning its limitations. That we are not there. Well, in fact, we're nowhere near there at this point. We have a really long time to go before we stop questioning. And I think if you stop questioning, I think then it's not the right use of the tool. You still have to question it from a human being and from a patient care perspective. So thank you, Amy. Thank you so much for taking the time on a Monday morning to join us and inform our audience. We also thank you for taking questions from our audience, and I'm going to hand it over to Hikbi for closing remarks.
Thank you so much, Amy and Dr. Dipu, for such an insightful discussion on digital health law. And let me tell you that this combination of legal guidance and clinical expertise is truly paving the way for innovation in healthcare. And we hope today's conversation helps our audience better understand how to navigate this evolving digital health landscape. And before we wrap up, I'd like to encourage everybody to register for the upcoming AI Global Summit that we are that will be taking place on 14th and 15th of December. So please do register. I'll be giving the links below as well.
Thank you.
So thank you everyone for joining us, and we look forward to seeing you in the next episode of MedSynapse AI series. Thank you, Dr. Dipu and Amy, for this insightful conversation. Have a good day.